When life gives you lemons, navigating the sour side of employment. Hi there, I'm Michelle Douglas from Burnham Douglass Law Group to help you understand the concept of quiet firing, or otherwise known as constructive discharge. Imagine coming to work each day where instead of being greeted with tasks you're capable and enthusiastic about, you're met with an atmosphere so tense and unwelcoming it drains your enthusiasm for the role you once loved. This isn't just a tough workplace. This could be constructive discharge. So what is constructive discharge? It occurs when your work environment becomes so unbearable that resigning feels like the only viable option. This isn't about having a bad day. It's about ongoing severe conditions that disrupt your fundamental right to a safe and respectful workplace. Under New Jersey law, constructive discharge is recognized when your employer's actions or the workplace environment becomes so intolerable that any reasonable person would be compelled to resign. But not every employment action that makes an employee unhappy is going to amount to an actionable adverse employment action. The courts have held that a intolerable condition has to be outrageous, coercive, and unconscionable. Also, before you decide to resign, you have to take every reasonable step necessary to remain employed. That means documenting the intolerable condition, reporting it to your human resources department or your supervisor, doing everything and anything possible to have your employer remedy the situation. So when is a situation legally actionable? Well, not all tough days at work are going to qualify as a constructive discharge. So if your employer doesn't say you're fired, it's not necessarily going to be up to you to just say I quit. For it to be legally actionable, there must be a clear violation of employment laws, not just the discomfort of working next to somebody who you don't like because he or she, microwaves fish. So let me give you some examples of constructive discharge. Harassment. Imagine being constantly targeted with inappropriate jokes or comments that turn your everyday work environment into a space of discomfort and fear. That could constitute grounds for which you could resign. What about a demotion or pay cut? Picture your role, once full of responsibility and respect, now suddenly reduced to menial tasks with no explanation or justification, or slashing your salary along the way. That could constitute good grounds for resignation. And what about placing you in a dangerous condition? Consider being moved to a work site that jeopardizes your health and safety and fundamentally changes the stakes of your job. Well, that could constitute as well good grounds for constructive discharge. Proving constructive discharge requires solid evidence, documented complaints to human resources, witness statements, documented complaints to human resources. You have to make a record of these intolerable conditions. It's about building a case that clearly demonstrates that continuing employment was no longer tenable. For instance, I had somebody contact me yesterday and I asked her why she resigned, and she told me why she resigned, which did sound as though it was pretty demonstrable and significant reasons for resigning. I asked her then, had she submitted a letter of resignation, and she said that she had, and that in that letter of resignation, she included that she was very happy with her past employment, that she had thanked everybody for the wonderful experiences at the workplace, and nowhere in that letter of resignation did she mention that she was dissatisfied or had any complaints about intolerable work conditions, or that she was being retaliated against in any way that made her quit. So that was not a good evidential background for her, and I had to explore some other issues and facts regarding her employment. But while she had a good whistleblower claim, that is, she did indeed report illegal activities that had been ongoing in the workplace, and immediately thereafter, she was retaliated against by regarding job assignments and being iced out of certain meetings and activities. I could not tell her that her resignation from employment was warranted. Although she had been retaliated against, it didn't amount to such intolerable work conditions that would have justified her resignation from employment. While I understood why she resigned, under the law, however, it would not have qualified. She did have a claim, however, for other acts of retaliation. Now, if you find yourself resigning under conditions of constructive discharge, you still may be eligible for unemployment compensation benefits. In New Jersey, if your resignation is directly due to an untenable job-related reason, well, this protection will kick in, and distinguishing from resignations due to personal reasons. If you resign for just personal reasons, to be clear, you will not be eligible for unemployment benefits if your reason for resigning includes a personal reason such as lack of transportation or lack of housing, childcare issues, attending school, or relocating for personal or family reasons. So in conclusion, no one should feel trapped in a toxic job environment, and understanding your rights regarding constructive discharge can empower you to make informed decisions about how to proceed in difficult situations. If you, a loved one, or a friend that you know feel that you've been wronged in the workplace and it's made your or another person's life situation intolerable, please do not hesitate to contact us at Burnham Douglass before a resignation, so that you are fully informed of your rights regarding constructive discharge or quiet firing. I hope this video has been helpful to you, and if so, kindly hit like and subscribe. Thank you.